We are going to have an interactive discussion. We got a few slides because, hey, it's design patents, and the slides, as Michael Rich pointed out on Twitter, are much cooler for design patent conferences than they are for utility patent conferences. But we're going to talk through a bunch of questions. Let me briefly introduce the panel. Starting on my right, Michael Rich is a professor at Villanova University School of Law who's written both in design patents and a variety of other areas of intellectual property. Michael Zeller is at Quinn Emanuel, which is one of the firms that was involved in the Apple-Samsung litigation, but Michael also is involved in international protection. Michael Jacobs at Morrison & Forrester was one of the lead lawyers in the Apple-Samsung case and a well-known local IP litigator in non-design patent areas, and now a design patent lawyer as well. Matt Schroers is here from the CCIA, the Computer and Communications Industry Association, which has obviously members with interests on all sides of design patent lawsuits these days. And John Pratt from Kilpatrick Townsend, yet another firm involved in that small case down in San Jose. So we're going to talk about design patents in high-tech and component industries. And I want to sort of frame this by raising infringement cases. We've gotten to vote on a bunch. Not many of them I would have called high-tech. So the question, I guess the first question to lead off is, what are design patents doing here in computer technology at all, right? Isn't this something that's supposed to be about, I don't know, wrenches or muffin baking separators? Let me turn to Mike Jacobs to start with this.
Thanks very much, Mark. I think I can offer what may be the last completely non-controversial proposition that I can offer this afternoon, which is that it's not just that the slides in a design patent conference are cooler than a utility patent conference. Design patents are cooler than utility patents. And of course, I love my utility patent cases too, but design is really a very exciting topic. And Mark asked this kind of fundamental question, and we've had a lot of talk this morning and early this afternoon about about the rules, but I think it's important to remember why we are in this at all. Why do we care about design patents, and particularly why do we care about design patents in high technology industries? And I submit that there's a very basic, simple reason. It's because we like our products to be beautiful, if they can be. We like our products to be aesthetically pleasing. We want a relationship with our products that goes beyond the mere functional, if they can be. Not all products can be beautiful. Not all products allow us to have a kind of a relationship with them. I submit that traffic signs on springs probably don't fall into that category, and we shouldn't get diverted about that kind of edge case when we think about the merits of design patent, or for that matter, product configuration protection. So Braun, of course, is, I think, the fount of beautiful, aesthetically pleasing products in high technology industries. The design of the products was noteworthy and distinctive. It created a brand identity. There was some discussion of that in the previous panel. And so when we think about beautiful products that have a use, it's useful to think about what Braun came up with over the years. You may have seen at the San Francisco Museum of Modern Art last year the exhibition that was there about Dieter Rams and his role at Braun and the 10 design principles of Dieter Rams. One of the points of confusion about design protection and Dieter Rams and his legacy is the role of minimalism in design. Dieter Rams was known for being a minimalist, and yet you can see from the Braun products that they are aesthetically pleasing and worthy, I submit, of protection. And sure enough, Braun was quite prolific in seeking design patent protection along the way for some of its products, including products that come close to being high-tech products. I think of Sony as another a company that kind of set a standard for design elegance when in the realm of high technology products, and they go back pretty far, and we all remember the Walkman and how distinctive the Walkman was as a product and as a design, not just for the way it worked, but for the way it looked. And then the Vaio has set a design standard up to the present day. And of course, Sony has gotten patents on its designs, and I would contend that those designs are worthy of protection, worthy of a protection with some breadth. All right, here's the one that really gets me, because Bang & Olufsen's products I have yearned for over the years, although I have to confess I have not sprung for them. But they're gorgeous and they're distinctive and they're worthy of protection. And I would suggest, in connection with the discussion that we just had about post-design patent expiration protection, that we think about an example like Bang & Olufsen, because some of those designs are so closely linked to the Bang & Olufsen identity as a company that I don't think it would be hard for the company to establish the elements of product configuration trade dress protection. But I also think it's not bad that you can't knock off Bang & Olufsen products even after expiration of a 14-year term on a design patent, which of course Bang & Olufsen obtained over the years, closely emulating some of the more distinctive products that Bang & Olufsen developed. We are seized of late with cell phones, so it's worth remembering that didn't start with the common era, if you will, of post-2007, but dates to some earlier designs. The Motorola StarTAC design was, for its time, I submit to you, a beautiful, elegant product design and product configuration. Motorola was not happy when Qualcomm came out with the Q phone. The Motorola product, interestingly, was an analog, what we would now think of as first-generation cell phone product. Qualcomm's Q phone was the pioneering 2G CDMA cell phone, but Motorola felt that it overtly copied and too closely mimicked the Motorola phone, so Motorola sued, and in an interesting litigation process, initially obtained a TRO, and then at the preliminary injunction phase, it was vacated. And it's a good case to read if you want to figure out, does this change in standard with Egyptian goddess make a difference? Because the reason the preliminary injunction was vacated primarily in this case was a point of novelty analysis, as opposed to a look of the product, the overall appearance of the product, taking it all together and looking at it as a whole. And so ultimately the case resolved. There was another interesting case that I think will maybe fit Mark's model of a component case. This is the Motorola Razr, also a very interesting design. This is the design patent. So let me go back. You see the shell-like shape of the keys. And this is a design patent that Motorola got on that distinctive design. And then VTech came out not with a cell phone, but with a portable walk-around-the-house phone. And Motorola sued on that design patent. So what's the point? The point is what we're going through now may be a particularly visible, high-profile, exciting, especially for those of us involved in it, dispute. And plainly it has given the whole area of design patents a lot more attention, which is great because they are so much cooler. But what we're really talking about is a policy goal of creating adequate incentives for industrial designers to create aesthetically pleasing, even beautiful products with which we can form more than just a technical or functional relationship, but actually come to regard in a deeper sense. Okay.
Well, so let's think about the types of technology at issue here. So I think Michael did a great job of pointing out that design patents can be high tech, and they're in some sense intimately bound up with the way we interact with our products, whether they're high or low tech. But all of the examples he gave us are hardware. So let me turn to Matt and ask you, is there something different about software? Should icons fit this framework, or once we're on a computer screen, should we feel differently?
So, we've sort of wrestled with the same issue in the utility patent context, where we've long understood that utility patents apply easily to hardware, and then had a sort of rocky transition when it came to software. And so, for the same reasons that dividing line has proved challenging on the utility side, I think it's reasonable to expect that it would prove challenging on the design side as well. And so, for that reason, I think trying to draw that line and say one is in and the other one is out is certainly problematic. But provided that we don't do that, we need to anticipate that we're going to have the same kinds of problems of abstraction that haunt the utility patent side are likely to haunt the design side as well. And so, I don't want to sort of pronounce against it, but I think we need to wander into the GUI territory with our eyes open. And if the current litigations that we've seen are any indication, I'm not really confident that that's happening.
Let me actually, at this point, Michael, why don't I ask you about that, right? So actually, I realized that there are 3 Michaels on this panel. Perhaps I should be more specific. Michael, so what's a Michael Sellers?
That was successful.
What is your experience with how Europe has dealt with these issues, how the U.S. Patent Office has dealt with these issues? What do we do with icons?
Well, one thing that I think is a fundamental question here that we haven't really talked about so much today, although I think it's embedded in a number of things we have discussed, is what are we really trying to protect? Europe, for example, through this harmonization process, is looking and it actually created a design rights regime. It is not the same thing as a design patent. Design patent is intended, as far as I've always understood it, is to promote decorative arts, ornamentation. That's the language of the statute. Europe, through this harmonization process, and it's actually implemented through national legislation, so it can vary somewhat, but the idea is to be harmonized through a directive and then subsequently a regulation. But it is actually avowedly to protect design rights of products. And certainly, I think almost everyone here is aware that over the years, people have lobbied Congress, the U.S. Congress, to actually implement something that looks more like a design rights regime, which Congress has not done, for better or for worse. So sometimes when I hear arguments about what the law is or what it should be, about design patents, I think sometimes we elide into what's really a policy kind of discussion about should we really have something that looks more like design rights versus a design patent system? And it causes me concern in the sense that, at least with a design rights regime, such as you have in the EU and in the member countries, there are a number of more detailed written regulations and statutes that help guide some of the very questions that people have been raising here today, such as what does the ordinary observer, which is, we'll call it the informed user in Europe, not the exact same standard to be sure, but nevertheless is sort of a corollary. It's a hypothetical person. Some of these questions people have raised here today, have been answered, which is that informed user is aware of the prior art. That informed user, in fact, looks at what the freedom of the designer is in actually coming up with a particular article or product. And that can, of course, include issues like functionality, perhaps even other considerations as well. And that is part of the infringement test that is actually used in Europe. So I think that in many respects, kind of what we haven't grappled with, and I'm not saying just here, I'm just saying more generally, as part of these discussions, is what are we trying to accomplish through design patent protection? Michael Jacobs has posited that one purpose is to protect beautiful designs. And I think that's a subject of debate as well. Is that really what it's attempting to do? There are cases over the years that have somewhat taken, I think, into consideration aesthetic concerns. That doesn't seem to be necessarily the modern way that we look at it today. But it does sort of pose, again, the question of what are we trying to protect with a design patent regime, which I think is a very different animal than something like design rights.
Okay, and so does Europe have an experience with doing this in the computer area?
Well,
have they dealt with icons in this design rights system?
It has. Some of it's the Apple versus Samsung litigation. I'm sure everyone is aware that it's not limited to the United States. There's any number of suits, including a number that have been played out in the European Union. And there was at least one icon case, and that was involved something in the Netherlands. One of the issues there actually had to do with the fact that users can, of course, manipulate icons on a smartphone. And ultimately, could someone, provider such as Samsung, be responsible for how the end user configures a design? And how does that really matter to infringement? Ultimately, they were found to be not infringing, regardless of who did it. And in fact, the Netherlands decision is somewhat, I think, informative about how many of these courts have treated these issues. Because of these other kinds of limitations and requirements and the kind of considerations that courts look at, both for purposes of validity as well as for purposes of infringement in the EU. The kinds of things I was talking about earlier, looking at the prior art, looking at what the freedom of a designer is, and looking also in particular what the industry is. I mean, that's a more kind of explicit context that's applied than perhaps we're used to with design patents. They're actually specifically looking at what do designers generally do in this particular field. They take into account the industrial field that's relevant here. And a lot of these work to limit the design rights and to ensure that we don't have these kind of broad conceptual protections that sometimes can arise where people talk about design patents and they're looking at them and trying to discern what the scope is of them. I mean, at least in Europe, that tends to work to reduce the scope of protection for these. In other ways, Europe has unregistered design right protection. That just arises by fact of the disclosure of the design in the EU. It so happens I was involved with the very first trial that ever occurred in the new EU rights regime. It was in London, the High Court of Justice of London, and it was for Mattel, and it involved a doll head. And the fact is that that protection arose simply because the doll was circulated in the EU. And one advantage at that time, and also certainly true today, that a prevailing plaintiff has the prospect, or at least the potential remedy, of a EU-wide injunction. I mean, I'm sure everyone is aware that one hazard of IP kind of just generally is it's territorial. So often you have to go to multiple jurisdictions if you believe you're an aggrieved plaintiff and try and play these out, but at least through the EU design rights, there's the prospect that in certain situations, if the court is seized of EU-wide jurisdiction, they can actually issue an injunction across the EU.
Michael, do you think there are discernible differences in the marketplace as a result of differences between the design rights available in the U.S. and in Europe?
I think that's an extremely hard question to answer because it's really an empirical one. And part of it also has to do with the fact that while design rights, these actual design rights regimes are not necessarily new in Europe, they certainly didn't apply across all 27 member.
Right.
And in particular, like say for the UK, for a number of years before the implementation of this EU design rights regime actually had its own unregistered design protection. And in fact, that was one of the precursors that ultimately led to this. But it's a little hard to tell to what degree this is ultimately going to play out differently in the U.S. Versus Europe. I just think it's a little too soon to say. I mean, the trial I was talking about, the very first one that arose, that we did for Mattel was October of 2003. So it's a pretty small time period on an EU-wide basis to really make that kind of a judgment. And I'm not aware of anyone studying to what degree this has had an impact on the marketplace. But certainly one thing that is different is with the EU. The purpose of it is avowedly, the whole purpose of this design rights regime is to protect product design, which in my view is a different purpose anyway, almost no matter how you carve it up, of design patent law.
Right.
All right, Michael Risch.
Yes.
We heard a lot about functionality in both Panel 2 and Panel 3, and the perhaps similar, perhaps different ways functionality applies in design patent law than in other areas of the law. How does functionality work in the context of computer software design patents? Don't icons do things?
They do. We talked about functionality all day as if it was this one kind of amorphous thing. And I'm not sure that's true. So I would break it up into 3 different types of things. And I'll give an example of each with something that's not computer software, but it's easier to grasp, which is the cupcake divider. I think the lowest level is basically operational functionality. How does it work? And so with the cupcake divider, I think the size of the base that has to fit into the cupcake tin is the type of operational functionality we might see. So a design patent for computer software, I don't know that we see that much operational functionality, to tell you the truth. It seems odd to say that because my gut reaction is to say that all of these design patents are functional, or many of them, but it's not really operational. You can do it different ways. It's not because the icon is doing a particular thing. There are ways to activate the computer that don't include a particular shape. So it's not clear that operational functionality will come to play other than, for example, the idea of spinning. So we now have animation of icons that are protected by patents. So, for example, on the Mac at the bottom where, and I have a picture of it, but we'll see it in a second, at the bottom where you activate from the bar and it kind of comes up in the cool way onto the screen. That is protected by design patent. The animation of the unfolding of a rectangular window. That to me is an operational type of functionality. Why do I say that? Because how many different ways can you unfold a window? Once you've decided that you're going to have the idea of unfolding the window, there's only so many ways to depict it. The second level of functionality, I would say, is the kind that most functionality actually falls into, which is this ergonomics idea. So with the cupcake holder, it was the idea that it goes up at the top and has the bumps because it's easier to grab. Yes, it makes it easier to grab, but is it truly functional? Well, it just makes it easier. It's not required. You could do it different ways. So with computer software, the ergonomics of it would be, for example, are square icons easier to touch than triangle icons? Is a grid aesthetically pleasing? Does it make sense to have a dock bar at the bottom that looks different? These are the types of things that I think can actually change over time. Things that are not functional when they start, because nobody has any idea, become ergonomically expected.
Can I ask you about the aesthetic point there?
Yes.
Because in trademark law, it seems to me we've got a pretty clear understanding. Well, maybe I should back up, right? I think there is a clear way to understand trademark functionality that makes sense, right? Which is, am I, in fact, motivated to buy this product because I think it comes from the trademark owner who I recognize, or do I like the feature of the product because it is either physically functional, it makes the thing work better, makes it cheaper to manufacture, makes it sell for more, or aesthetically functional, right? It looks cool. I don't care who makes it, I care because it looks cool.
Right.
And if either of those latter two things are true, in trademark law we say no protection, because that's not the point of trademark protection. But isn't aesthetics the point of design?
Yeah, that's the problem. Looking cool is what gets you the design patent.
Okay.
So now you're in trouble. So
well, or out of it. You're entitled to protection.
Depends on how you look at it, I suppose. If you're infringing, you're in trouble. If you're the patentee, you're not in so much trouble. So yes, that's true. So I don't mean the aesthetics of it because it looks cool. I mean the aesthetics of it because there's some sort of a de facto type standard where the look of it becomes functional. How do I define that? I'm not sure. How do we know when it's happened? I'm not so sure. But at some point, we know that people expect to see a grid of icons on a touch screen for cell phones. So Apple might argue that it's because of that it's because of them, and now everybody expects it because of rampant infringement. Samsung would say, well, Apple did it, but over time, this is just the way touch screen cell phones work. Oh, and by the way, there's prior art. BlackBerry had icons in grids, etc.
So two decades ago, Apple brought a lawsuit against Microsoft, right, alleging that the graphical user interface concept was their copyright infringement, right, and the argument was, well, you could do it another way, right, and people had always done it another way. You'd use text-based displays and operating systems, but maybe now we would say, okay, everybody understands that a graphical user interface, a Windows-based model is the way that people expect their computer to function.
Right, and so now that leads, over gesture, that leads to actually the third type of functionality, and I've got an image of this, which is Apple versus Microsoft was really about the ideas incorporated in that operating system, the desktop motif. So, okay,
I think we're about to see it operate, right?
There we go, patented. Patented. All right, so here is a slide. It's from, I got it from The Verge, but it's from the Apple Samsung case. On the left is the 305 patent, which was found infringed. On the right is the Fascinate. Note, when I gave this talk in Philadelphia, I won't ask here. I don't want to like bait my co-panelists on this because this is an actual live case. When I presented just the patent and just the grid and said, "Are these the same?" People said no. They're different. Why are they different? Well, it's different icons. There's more of them. The dock icons are different. The dock background is different. Or maybe they would have said, let's see the prior art, according to what we talked about earlier. I didn't get that far with them. But look at the analysis that's going on here. What's the comparison going on? The idea of a grid. The grid has different numbers. The idea of a rounded rectangle. The icon for the same function is different. A mix of icon styles. Now, if that's not functional, because if they all look the same, it wouldn't work very well now, would it? Colorful icons. And a bottom row. Now, of course, we know that the bottom row stays the same regardless of the screen you're on, but that's not part of the patent. So it's just a bottom row with different shading. And here the different shading is different. And note that the icons and the functionality are different. And so the argument here is the exact type of thing that lost in Apple versus Microsoft. Because the idea is if you do the abstraction filtration comparison test and we abstract out the ideas of a grid, rounded rectangle, mix of icon signals, colorful icons in the bottom row, and then we compare what's left over, all you have are the actual icons themselves, and they're not the same. And so the question is whether or not this level of functionality can be protected by a design patent. I think, should the D305 interface be protectable as a design patent? Sure, why not? The question is, how broadly do we look at for infringement? Should we require filtering? Egyptian Goddess says we probably should filter. Richardson does it in the bench trial. In this case, Judge Coe said it's okay to do it. In a bench trial we might do it, but it could confuse the jury, and the judge has discretion. And I chose not to do it in this case for a variety of reasons. Egyptian Goddess gives her that discretion, theoretically.
Can I ask you on the, Michael, on the
so that's the functionality.
Well, so can I ask you on this functionality point? You said, I think, and I think I agree, right, that even if we think each of the individual elements that you've identified here in the comparison are themselves functional, that the design patent itself has some non-functional elements that it ought to be protected. So if I copied the thing as a whole outright, identical duplication, Apple ought to have a cause of action against me. Right?
And the question is, how close?
Well, okay, but doesn't that suggest that functionality doesn't belong in the validity side of the analysis at all? It belongs in the infringement side, right? That what you're saying is not there's no patent here because the elements are functional, but there's a patent here, it's just one that's narrowly circumscribed by the limitations of functionality, so that only very close copying would be infringement.
I think that's true for a complex combination. I think the more simple you get on the design, the more role it has in validity. So take best log. That was a key blank. The actual key, what they'd done was taken the key and basically curved it. And what they wanted to do was outlaw making generic keys that were curved. They didn't get a utility patent, or maybe they did, I don't remember. But they couldn't protect it by utility patent, and so the key blank was out there. And a good point was raised today. Well, it was a pendant. Why not call it a non-functional pendant? And the court kind of did not go with that argument and said, for something this simple, to allow a patent on this would outlaw. We can't filter that out. Filtering it out leaves you with zero. And so I would say that for a combination, you can filter out the ideas and you're left with stuff to compare. But as you get simpler and simpler and simpler, when you filter it out, there's nothing left, well, then you're at the validity stage.
I don't see those as being functional elements. I don't see mixed icon style as a functional element. I don't see colorful icons as a functional element. I mean, those seem to be characteristics of the appearance. And I think the appearance to appearance, and if the appearance of the mix is different, then that's going to go to a different style. You're going to compare them, and if they have a similar appearance, and they're going to infringe. If they don't have a similar appearance, they're not going to infringe. I don't think colorful icons is a functional characteristic.
The problem is, where do you get colorful icons from the drawings? From the drawings, I see a list of icons. There's a gazillion colorful icon patterns.
I agree, but you're saying that you want to somehow filter out the 305 patterns. Well, we can filter out functionality. And I don't know if I see any real functionality.
Well, I'm equating functionality with ideas. Let me put it that way.
Michael, give Matt a minute.
So that sounds to me like the notion that a monochrome screen is as useful as a colored screen, right? We like colored screens because we use color to differentiate things. So because it provides a differentiating factor, we are relying on the function of the thing. And the same with the nature of the icon as well is, different icons allow us to differentiate things, right? It would be a lot less useful of a display if it was just text, right? We used to have that, right? It was called DOS, and we got away from that for a reason, because the sort of graphical element is more useful, right? I mean, these are sort of, we are depending on the utility of the thing in order to make it more useful as the user.
Can I comment without commenting?
Yes.
I think much of what is here would be filtered out, and certainly, as Michael said far more clearly than I did this morning, would have been filtered out under a copyright analysis, right? I mean, sort of scenes of, and so we're coming out with a decidedly different result.
So here's the problem, and I don't, the question of how design patent law is it? We don't want people to find infringement because they see similarity. If the similarity they see is merely that they both have colorful icons, right? I mean, unless you disagree with Matt that sort of black and white is equivalent, if it's just that they both have colorful icons and that makes an ordinary observer think, oh, these are similar, that would be a problem. All right. Michael is going to comment on a hypothetical case and not the one here behind us.
The way this is done, the way the copyright case is litigated, the way design patent cases are litigated, the way functionality and trade dress is litigated, is not to look at a snapshot of one point of comparison, but to look at a spectrum of comparisons. And so when you're proving the idea expression dichotomy in copyright law, you would assemble the words associated with an array of works that are in the same category, and you would distill from that array of works as a matter of advocacy what the ideas are and what the expression is. So take the classic case, you would take Romeo and Juliet and you'd take West Side Story and you'd take another romance where the couple ends up in terrible situation. You'd say, see, these are the common elements across these plots. These are the plot elements that are not protectable. They are ideas. Here's the expression that you distill out of it. Similarly, when you're doing functionality and trade dress law, you look at what the alternatives are and whether they meet the test for demonstrating non-functionality. So caution about any particular slide. I happen to like this slide, but caution about any particular slide. One really has to look at the array of information that is before the decision maker to see what alternatives were available and therefore what one can distill out by way of, in this case, functionality.
Okay, we've prompted discussion. I have at least 4 audience members. Mark.
So I have people observation. I don't have a solution to it, but so implicit in what you just said, I think, is you get an array of other choices that are all in the same category. So query first, how do we define the category, right? And then second, I think this is a problem that pervades functionality and trademark, is that if you want to talk about whether this serves a function, you have to decide the level of generality in which you're going to describe the function, right? And so that's a really significant problem here, because black and white icons are just as good for a function if you describe the function in a particular way. If you describe the function in a different way, right, they need to stand out, which then all of a sudden black and white starts to look different. And so it just leaves lots of opportunity for creative ways of talking about this if we don't have a sort of baseline way of doing it. And then when you start talking about the alternatives, if we're talking about whether other alternatives that you can use are technically substitutable, or if they'll be equally as good as a market map, right? Whether consumers will actually like them as much. So that relates to the standards thing I point, right? But the standards point is that if consumers expect there to be a bottom row, it doesn't really matter whether technically you can do something different. And so you have this sort of different things going on: level of generality of description, and then also technical substitution versus market.
All right. Yeah, I'm coming. Okay.
I've been struggling with this because I think the word functionality can have to be too much. And so, Michael, as you're trying to say, well, functionality actually comes in 3 flavors. I actually think the moment you make that move, what you're really saying is functionality is not the right word for really something.
That's right.
We have that same problem in trademark law with respect to aesthetic functionality. There may be some kernel of a good idea that it's trying to exclude from trademark law to aesthetic functionality, but that avoiding is horrible. And I think that I don't understand why we have to use the word functionality to screen out some of the times when things come. I come back to that cupcake example. There's no functionality problem with the fact that things look like a cupcake. And the moment you say, I'm trying to make a cave separator that looks like a cupcake, there's a certain set of inherent attributes that are not controlled by design production, the idea of a cupcake. And they're not functional. They're just inherent in the concept that's being executed.
So you want an idea-expression dichotomy, basically.
That's what I meant by saying the fair point. When we use that terminology, we
notion that there's certain things that are endemic in a particular delivery. And so some of the icons would lend themselves to that same kind of treatment. It's become the way in which we expect. When we say there's going to be icons right on a page, we expect that there's a certain set of actions that are going to follow.
Okay, so there's two things. One, on the cupcake, there is functionality. The size has to match.
But take out all the functionality piece out. There's still going to be something.
Well, that's true. Now, the sense of fair, here's the problem. Apple had this first, and they did it before anyone else. So it's only sense of fair if everybody starts doing it.
No, but we've had icons in rows for long before anybody's been,
I understand that. I'm just saying this particular thing, deciding what sense of fair is not so easy, I don't think. I mean, it's a nice solution, but it's not so easy in practice.
Please don't use the word functionality to describe it.
Well, I agree with that. I agree with that.
Okay, so you actually see here is truly an aesthetic implementation on top of high-level functionality. So you can separate these out by the way in which they're structured and the way in which they're designed. What I think you have here is a lack of understanding of how one creates these things actually progresses from a conceptual point of view and makes decisions sort of the transition point between aesthetics and functionality. There's a whole science behind what makes function.
Right.
And the second point is, which you're incorrect, is that actually icons take more time to learn and are harder to read. That's why almost any individual that we see has a text over an icon. The fastest interface are those
But the icon clearly has a function in a touch screen, right? So that is, it's no accident that they are of approximately the size they are and approximately the shape they are, right? So that when I hit my finger on them, I'm not hitting the three around them. Right? So they're clearly constraints. It's not to say that everything that's on the screen is dictated by the constraint. Far from it. But there's got to be at least some similarity that is dictated by the fact that these are icons, and they're going to perform a function, which is I'm going to stick a finger of approximately a size from kind of a small child's finger to a larger adult's finger, and hit the button and not hit the ones around it.
Absolutely, but that's the functional side.
Right.
The aesthetic side of it is the actual
Right, which is
functionality is designed has an inherent impact on the borderline functionality. There's a science behind that that we're trying to cover up.
right, sure.
So I think you guys just touched on a key issue, which is that you can't use the word functional for anything that has to be perfect, right? It's all very clear that in order for an element of design to be functional, it has to be dictated by its use. And so you can't say that this design is dictated by its use because, for example, you look at Windows or OS, which has it does not have even a grid of icons. That is very well self-controlled as long as people like. And so I think we have to be very careful about the word functional. That if you leave anything out of the design, it's sort of taking
So I guess I would say I am not the design patent expert. When functionality in copyright and trademark means something substantially broader than just dictated by use. I don't know whether that's true in design patent law or not, but if it is true in design patent law, right, then design patent law needs a concept in addition to functionality to do most of the work that functionality is doing in copyright and trademark law, right? Because it can't be the case that if yours works better than mine and that's why people chose it, the fact that I copied just the bits that made it work better makes me an infringer. So does copyright law, but we run into these problems, right? Because we want to cover useful articles, but we don't want to give you protection in design patent for the useful bits of them, right? And that's the problem I think we run into.
So the copyright laws had basically 20 years to figure out how to adapt our relatively antiquated vocabulary like authorship, merger, de minimis, scenes affair, to highly functional stuff that it wasn't originally intended to do. And we're just starting that learning curve on the design side. And that's why I said when we started that this is something, we can't categorically say no design protection, but it's something that we need to go into with our eyes open and from a sort of terminological standpoint, I don't think we're doing it.
Well, the closest analogy in copyright may be architectural plans. Architectural plans are kind of sui generis protected in the sense that they're called out and they have their own line of cases. And if you think of something that is both beautiful and useful, I think of houses and buildings. And by and large, that has worked out okay. I don't see, I don't get the sense that architectural plans are being overly protected, even if that means you have to go back to the architect when you want to get a copy of the plans. So it works in copyright law to protect something that is both useful and has design elements. I don't see why, I think we're making this overly hard.
How many architectural cases are there that don't allege direct? I mean, most of the copyright cases in architecture that I know is that I've read, and that's not that many. It's where the client goes, asks an architect to draw up plans, the architect draws up the plans, and they take it to another builder who's going to do it on the cheap, and then he sues, the architect sues. And that is actual copying, right? But that's not really what we're talking about.
Well, I think we are actually. I mean, the point was made this morning that most design patent cases are product copying cases with a proxy in the form of the right. Michael's suggesting maybe the rights aren't quite right to protect against product copying because maybe we should have a product design protection rather than this thing we call a design patent.
Well,
but it's
I mean, to me anyway, the fact is we don't have to look to an analogy. I mean, in the copyright circumstance, we have Apple versus Microsoft dealing exactly with icons. And what the Ninth Circuit found was, to some of the points that people have been talking about, is that certainly they recognized there was an aesthetic dimension to it. Certain design choices could be made, but they also recognized it was at least in part functional. And for example, one of the icons that was in question was using a wastebasket to communicate the idea that that's where you put your trash. And the Ninth Circuit said that, at least in part, is communicating information to a user. That is not something, call it functional, call it what you will, that's not something that copyright is going to protect. Copyright does not protect the conveyance of information. And so that was the fundamental nub of what the Ninth Circuit ruled in this exact same situation involving icons. So there is a...
And the analogy here would be let's say the phone icon up here, right? So
right.
That phones don't actually look like that anymore, right? But they used to, right? We recognize, everybody who looks at that thing says, oh yeah, phone, that's to make a call. It is clearly possible... My kids. Yeah, exactly right, fair enough. Everyone in this room. Your kids have no idea what that weird thing is. It's clearly possible to sort of depict a phone in another way. You could depict an old kind of standing bell telephone, right? You could depict an actual cell phone, right? Which is closer to what they would actually be doing. But the fact that there are alternatives, I think, doesn't mean that it's not serving some purpose. And then the question, I think, for design patent law is, right, to what extent do we care about the fact that it is serving a purpose as well as looking like interesting design?
I guess one point on the functionality, I didn't mean to say that this third category was true functionality. I was using that as a springboard. It's more idea than functionality. And then second, I'd say on the architectural, I think there are carve-outs in the architectural for specific design elements so that you can't own a particular type of bathroom when you draw up plans for exactly that reason. When you design the whole thing, you don't get to own all the little pieces and the ideas you put into it. So if you have the idea that you're going to have 4 bathrooms on a floor, you don't get to own, I have 4 bathrooms on a floor, when somebody else comes up with a different architectural plan. Christopher.
The discussion is comparative analysis of various IT regimes. But certainly, I think there shouldn't be a notion that they have to replicate each other from IP right to IP right. There's different qualifications, different statutory rights, different policy reasons, different terms, different remedies. for each one of these. So to somehow, and maybe it's an unfortunate semantical choice, we have the same word that seems to run for each one. And I would posit that it isn't even proper really to be using the term functionality, because as a speaker back though, it's ornamentality. That's what the statute says. And I would also say we should back up this idea. We're talking now on a feature by feature basis, but that's nowhere found within the statute. And to say that any of these are functional and say that we're supporting Chips Jagadas, I think that's a little bit misleading, because Chips Jagadas wisely used the modifier purely functional. It never just says you have entitlement to function or to filter out any type of functional features, but purely functional. And I think I would agree with Rob here that I don't see how any of those are purely functional. There's certainly myriad ways, and it's so easy.
Chips Jagadas, that's not what it says. Right.
This is the only way that this can work. You just won't find a designer on the planet who would say it.
Dennis?
I was going to make the same point for just because, right, that I think you can have a perfectly rational design type regime that doesn't even have this functionality doctrine at all. It just allows you to patent these things, and sure, maybe somebody maybe the reason someone has copied your design is because they like the functionality of it. And if you have a design patent and they copy it, when you sue for infringement. And we can perfectly have that story that in 2 years once it's expired, right, you won't be able to get a trade, you won't be able to get trade dress protection, and you won't get copied as much as they want. That's a perfectly rational system. And so I don't think we should begin with your assumption, Mark, that we all think that just because they shouldn't get patent, right, that the functionality shouldn't drive the infringement.
I think I'll agree with everything in that statement except the words perfectly rational. Because I think it's absolutely right to say you could have the system, and it might even be the system that we have in design patents. And so the point that sort of the copyright analogies are not necessary ones is great. It strikes me that if we're going to eliminate the real sort of ornamental functional distinction, and if we're not going to do a lot of examination on the prior art merits, as Dennis is trying to suggest, we're going to end up with an awfully broad right that's pretty hard to circumscribe, and maybe we want that, but maybe we don't.
Yeah, I would take real issue with what Dennis suggested, because think of the word equal. Somebody came up with the word equal, and it probably, if you really get down fundamentally, it's not the world's best design. And it's the way we all learn to time. And the fact that somebody first came up with it should mean that nobody can use the word equal as much as we do. It just defies logic. We would all have, if you go to Remington, you get quality. If you go to Olivetti, you get somebody else's keyboard. If you own a Mac, it's one kind of keyboard. If you own a Lenovo it's another. Well, that's lunacy.
Like different operating
It's like
systems.
saying stoplights can be read in one country and green in another.
Yeah, so
Let me
what
just
we're,
make-
Or like driving on one side of the road in one country and the opposite.
yeah, I've done that. That works out really bad.
That's lunacy.
Let me just make this observation. Let me just make this observation because we may be beating this horse.
Yeah, we're going to get out.
If you go to a store now and buy a tablet or buy a laptop or buy a cell phone, you will see a broad array of differentiated user interface designs. And you'd be hard-pressed to look at it just facially like we're looking at this slide and say, oh, that one won't work. There is an incredible variety of art in this area, and some of them are beautiful, and some of them are a little kludgy, and we may even disagree about which is beautiful and kludgy. But this is not the QWERTY keyboard. There are a ton of choices available, and you could see it for yourself. Just go down to Best Buy and check out the new stores.
But there
All right,
were-
so
I mean, what we're really talking about here are standards. Right? Is that we have standards and we expect interfaces to be somewhat standardized. Right? And so the QWERTY keyboard, we stick with it not because it's good. Actually, it's deliberately bad, but we stick with it because of path dependency of the standard. And if you were to say that every time you opened a door, that the doorknob interface was going to be different, not because somebody was trying to come up with a better interface, but because they were compelled to come up with a different interface, then you're going to have a hard time just opening and closing doors, because there are things that we need to interface with all the time. And to suggest that property rights can extend to and foreclose the stuff you have to interface with is a really dangerous notion. And today, the stuff we have to interface with is that.
Okay, so it's clear to me that we should have called this the Design Patent Functionality Conference and put the entire conference on this issue. But nonetheless, I would like us to reach at least a couple of other issues in this panel. So let me turn, if I may, away from I think what we started with Michael and the shape of the entire product, and then Michael Risch brought us to an image of the sort of shape of the basic screen of the phone. But there are design patents on smaller components than that too, right? There are patents on the icons themselves, and I don't know if you've got examples up there to show us. Great. So what's different about patenting an icon? If I can patent all of this, can I patent one of those icons? So how about the phone?
So let me go through a couple of these. I don't have a printout, so this is kind of a we'll see what's there. Here's where we start. Actually, it's in Ruby. It's a patent on the design for the water in the fountain. And it was originally rejected because it was ephemeral, it was moving, it could be turned off. And the Federal Circuit said, that's okay. This person is selling fountains, or I suppose shrubberies, if they were going to sell that. But they were selling fountains, and the court said, look, if you make the fountain look like this every time, you get your patent. We also have Zahn, which is the broken line. This is a patent on a shank. The shank is obviously not functional at all. It's clearly ornamental. I guess, I mean, from where the line is, I guess it's that it's indented, it's got the little loop there. It was originally rejected by the examiner because it was not claiming the entire thing. And so Zahn said, all right, I'll do a broken line, because they had initially basically put the entire drawing, including the entire drill bit, and the examiner said, no, because the drill bit's totally useful. You're not, and your description says it's just the shank. So he said, all right, I'll do the shank in a broken line, because the broken line, as we learned earlier today, is stuff you're not claiming. And the Federal Circuit said, sure, why not? It's very clear here. This is just for the shank, and the drill bit is for context. Now, one question that I think doesn't get answered, and this comes up in the In re Owens case that was kind of mentioned, I don't know if that was mentioned earlier, it was about the Colgate bottle, is what context is there? What is allowed to be put on the end of that? Does it have to be a drill? Can I put a shank on the end of a truck and still have it be patentable? I don't know the answer to that, but I think it matters. And I'll tell you why it matters. We come up with animations. This, I think, is a cool one. You can see where this is going. It had 12 images. And it was a little bubble that moved for every hour, and the minutes were in the middle. That was kind of a whole interface. Here's a piece of one. You might recognize this image. It's an ornamental design for a display screen. Here's another one. Picking on Apple a little bit. It's an icon for a musical note with the circles. The dotted line means that there is a display screen. And the way it used to work was people would just try to get the icon. And the PTO freaked out and said, you're just getting an icon. That's copyright. You can't have that. And so they came up with new rules. Just do a dotted line and say, well, it's an icon on a screen. All right, now we have an article of manufacture. And that's the rule to this day. Dotted lines, broken lines, it's an icon on a screen. We'll see what else I have. There is your patent on the expanding rectangle. Here is one, and I actually think this one is close to functional, although not exactly. It's the book turning animation. It's functional because it looks just like a book turning. I think it's not really functional because a book turning doesn't look exactly like that. But
Wait,
it is
so
for
let's
an
suppose
animation.
let's suppose a book turning did look exactly like that. Why would that make it functional?
Well, because the idea is basically you're now patenting a design on a graphical representation of a book turn, which would mean arguably that if somebody videotapes a book page turning, they've infringed if they show it on a television. As long as it's on a tape, it's
What
okay.
implication does that have for patentability, though?
Well, because it's purely functional is the argument.
No, that's what.
Well, maybe it's anticipated too.
It-
I don't want to get into the functionality. We'll skip that. All right. Here's one of the original patents. This is for a turning icon. It was for a cell phone. I think this says Cellco partnership. I think it eventually went to Verizon. I could be wrong about that. It's basically back when cell phones were way, way slower than they are now. You're waiting for data, you're waiting for signal, and the cell phone is turning to let you know that instead of your turning mouse or clock.
Thank God we don't wait for data and signal now.
Yes, of course not. Okay, so here's the point with all of those. The question is, what is an article of manufacture? All of those were images with broken lines saying, put it on a screen. What kind of screen? The thing that scares me the most about that rule is this. Take a picture, send it in with a broken line. Now you've got a design patent. There goes your fair use for copyright. Take an image from a film, send it in for your design patent. Now there goes your fair use for YouTube, for any kind of clips, for any kind of anything. We know it's going to be valid. Nothing's anticipated. We saw the data.
By your own? Well, no, but not by your own. If the image has never appeared before, if you wrote
The
it.
image has never appeared before. I take a picture of this audience. When has this audience ever been together? I have done a design of this audience on my cell phone. I'll show you the picture of it. I'm going to send it in, and now if any of you took a picture or try and share it on Facebook, you are infringing. Assuming same picture or one close to it. It doesn't have to be exact. We just saw that. Maybe it's a slightly different angle. Maybe it's a different room with different people. It's a series. Hey, listen, colorfully dressed people with heads in rows with tables going up.
I swear.
All right. So, okay.
They're rounded.
So that's concern number one with the ephemeral nature. But a bigger one that's more realistic today than the copyright one is, when do you infringe? What if you update? Facebook announces Facebook Home. So apparently my ADW launcher is going to be out the door. I'm going to use Facebook Home. It's going to be so great because now I can see a picture on my front page instead of icons that actually let me do stuff on my phone. But it's a skin. What if their skin has icons in a grid with a dock? What if it has that? Is it an article of manufacture? They pushed it out to my phone. Is Samsung liable for that? It's obviously Samsung has a product that's in use. It will have the launcher on top of it. But it wasn't sold that way. Are they inducing it by sending out ways to have people do an API for a launcher? This is a problem. And it's not just for the whole interface, it's the icon. If the icon is pushed out later, and I'm not talking about a day later to try and get around having the sale, I'm talking about much later, a year later, 2 years later. You change your interface design. Does that mean all of a sudden that the thing you sold before becomes an article of manufacture? And even if it does because you put it on your new stuff, do all of the old phones you sold last year become eligible for damages? Because as we're going to hear later, it's 100% of your profits on those phones, even though the design was not on the phone at the time it was sold. This is a real problem. And then we have user modification. Launchers come out with 3. When my wife bought her HTC phone, we got it in before the deadline of the ITC, although that never materialized, that injunction. There were 3 icons in the dock. And I said, wow, how ridiculous. That must be because of some patent. Apparently it was. So we immediately added one more. And now she has 4. Is HTC infringing?
No, but you are.
Probably. But am I? That's the question. Am I? If I created a new article, I'm using an article of manufacture. If you read 271 clearly, it is, I am using an article, I'm using a patent on the article of manufacture. But that's problematic when it's ephemeral, to me. So that's all I have to say about that for now.
And if I can go back to one point too, which is people have been sort of positing, well, why should we treat design patents similar to, say, trade dress or copyright or some of these more robust protections? We'll avoid a label, call it idea, expression dichotomy, call it functionality, call it concept, call it whatever you will. But the fact is that there are those kind of robust doctrines that are used to limit the scope of those intellectual property rights for policy reasons. It is to promote competition. People have sort of thrown out the idea of, well, we can issue these design patents, give people 14 years. What's the big deal? They'll eventually expire. I mean, 14 years in the field we're talking about, technology. Could you imagine if basically all competitors had to stand by and wait for the expiration of a patent before they could use? And I won't pick on particular examples up here, but come up with any example that you want. That you couldn't come up with a clamshell phone. You had to wait 14 years. I mean, the lifespan of some of these products means that 14 years is a long time. And that's long enough to stifle competition. And I'm not trying to talk about particular examples in which this can occur, but it's not a cost-free kind of equation here. It's not just simply we're going to protect design at all costs. And other people suggested, like, well, functionality shouldn't even play into this. The statute says ornamentation. Embedded, implicit, however one wants to characterize it, functionality cannot be part of that. By definition, it is not ornamental. And again, the purpose of this is to promote decorative arts. It is not to simply give people design rights writ large. I mean, if people want to move to such a regime, there are certainly models that we have in other countries that people can follow. They can lobby Congress. They can do what they want. But to take a design patent regime that was created for one purpose and try and broaden its purpose, I think does create real dangers.
Crystal.
Just a quick point. I mean, if indeed a designer has arrived at the optimum or the best design, okay? I hear two sort of cries. I hear one, the idea that in the design pattern is too fundamental, and I hear the other when people try to say that they're too trivial. I mean, if they're too trivial, then just sidestep it. Go a different direction. Design around it. If they're so fundamental, well, isn't that a system? I mean, boy, oh boy, someone's arrived at the best design. Why do we want to honor that? So I keep going back. It reminds me of an old jazz standard. What are we afraid of? And what are we afraid of? I keep hearing, oh, what's the province of utility? Maybe we can answer that question. What are we afraid of if we do allow that? We allow that design patent claim to go forward without all this post-hoc tinkering and hacking away, and let alone the effect that it does to Section 282. Because from everything I've heard up there, it sounds like 282 would mean anything, the presumption of validity. If you've done these sort of fundamental changes to the claim, the people believe in the presumption of validity, you have to be done some post-hoc tinkering.
Can I ask, how do you arrive at the best? Let's just subjectively agree that it's the best design. If we're talking about ornamentation, that's like saying the best movie, right? If it's best, it has to be objectively better than something else. And if it's strictly ornamentation, has no functionality, it can't be the best.
I'm in agreement with you. That's why I think this entire exercise is futile.
But I think what I'm saying is, but that was a straw man.
So I don't think that you can go down that path at all, because to say something's the best, you're not going to arrive at that. So to say something, why are we going down this entire path trying to identify functional features?
Well, I mean, it seems to me the risk is that if we let people would love to have broader rights rather than narrower rights, right? And so if we let them, they will happily say, my copyright on my song is not on this particular song, it's on rap music, because I'm the first person to come up with rap music, right? They'll happily say that their trademark is on the wheel, and my design is that it was round, and people recognize me as the maker of round wheels, and nobody else can do it. So, leaving aside the question of whether design patents present the risk, and I think people can and are disagreeing on particular issues there, right? I mean, I do think we want to we do want to limit the scope of IP rights for policy reasons because we think competition's actually desirable, and so is design, right? So we want protection, but we also don't want unlimited protection. Right. Sir.
So I got the impression you didn't really like the idea that there should be protection on icons and photographs and pictures of heads in a room. But I come back to the article of manufacturer's requirement, which is when that came up, that was kind of like anything that was sold was an article of manufacture. And I don't see a problem with an interpretation, which is sort of anything of value that's sold that you can describe, kind of put a box around it like it's downloadable or it shows up on your API. I mean, why is that not suitable to be an article of manufacture? If it's worth 10 cents and you can define it, why is that any less protectable than a pencil sharpener?
First of all, I don't want to say that I disagree that icons should be protectable. I think that you can protect. I think some icons, I'd like to see some better examination whereby non-obvious icons get patents and obvious ones do not, let's say. But I'm not saying they shouldn't be protected. What I'm saying is I worry about the ephemeral nature because the icon lives in data, and the data can be pushed around not on a display screen. And so the icon can be popped up later, and it's not being sold. It's being dropped onto people's devices. It's being dropped onto people's devices by somebody other than the maker of the article of manufacture. They're not selling an article of manufacture. They're selling bits of data. They're selling images. And then to say it's infringement because the image happens to show up on a device that was sold 3 years ago, to me is problematic as far as certainty is involved, and it goes both ways. Because, for example, one of the defenses by Samsung was on some of these, there's the Google search widget. And then we've got the icons in the dock bar, and see how different this is. And then, yeah, that's one screen, but you go to the next screen and the widget's gone and there are the icons. Anyone who's used Android knows what I'm talking about. You have different screens and so there's this debate about is it the main screen, is it not the main screen? And if the widget is there, you can easily delete the widget, and then it looks just like the design, let's say, like the design patent. So it's still ephemeral, and that's a problem.
Let me get Paul, and then I want to move us on to the remedies question. Paul.
Thanks, Mark. Recognizing that there needs public policy limits on intellectual property protection, I take exception to your framing of the question. It is not in the nature of any single intellectual property owner to say, I want the broadest possible protection I can get. By definition, intellectual property owners today are intellectual property users tomorrow. We all exist behind a veil of ignorance where we don't know which label is accurate and now, given that, there is built into the system constraints in addition to those components, let's say, like remedies, functionality, whatever. We all have to compete with the business. We don't know which side of the line will be on. So that turns to my zealous point about, well, are we going to shut down innovation for 14 years under the label of design patent? Somebody comes up with clamshell telephone, are we all at that off limits for 14 years? The relevant policy question at that point is, what level of innovation are we stimulating? We could be stimulating a high level of innovation that says, yes, indeed, you get 14 years on a clamshell telephone. Anybody wants to compete needs to come up with something better, as companies certainly have done. I'm not suggesting that's the right level at which to set innovation. But innovation is competitive. And how we define the scope of protection will in turn define the level of innovation that we get. A priori, I don't think anybody in this room can tell us which is the right level. Thank you.
All right, so I want to move us on to remedies, because one of the things to an outsider to the design patent world that's the most surprising about design patents is Section 289 of the patent statute, which provides that if you win your design patent case, you are entitled to the defendant's entire profits from the sale of the product. Now, that's a statute that was written in the 1800s after a rug case went to the Supreme Court, and the Supreme Court applied the rule that is the rule in all patent areas and has been for a long time, which is apportionment of damages. And they said, okay, well, yeah, you copied the design on the rug pretty exactly, but I don't know, you haven't proven to me how much people just wanted the rug to keep their floor warm and how much they wanted the design, so I'm not giving you any share of it. Instead, I'm giving you 6 cents as damages. Apparently, $1 in nominal damages was too much money back in the 1870s. Congress didn't like this result, and so Congress passed Section 289, which says you get the entire profit. And the theory behind it, the Congress said, was twofold. One is, you know what, if there's infringement of a design patent, it's pretty much always the thing that's driving the sale of the product, right? You copied my design, that's why people are buying the product. And in any event, the court says, design patent infringement at that time requires willful copying. It's a willful infringement test to prove design infringement. So it's not like any innocent infringer is going to be liable for all this. We're really going to get the counterfeiters. Well, fast forward to the world that Michael just described, in which you get a patent on the music note icon. There are a bunch of patents in the Apple-Samsung case, design patents in the Apple-Samsung case, some of which are quite substantial aspects of design, some of which are smaller individual components of design. But there's also a bunch of non-design patent aspects of that case. There are technical or utility patents on slide to unlock and various other mechanisms. And then, of course, there are the aspects of the phone that make it valuable that have nothing to do with the design. It calls people. You can send messages to and from it, and a lot of people find those to be valuable aspects. But under the design patent law, if there's one design patent that's infringed, the entire profit from the sale of the entire phone is attributable to that design patent, and it gets paid to the plaintiff. And indeed, I think one of the reasons that the Apple-Samsung number is as big as it is that is not because of the functional utility patents, it's because of the design patents at issue in the case, driving that number. And there's some question as to whether the jury in fact awarded all of the patents, all of the profits as it was supposed to do under the statute. But I think so I just want to sort of flag the oddity of this. I mean, it is in current law the rule that if you win your design patent case, you are entitled to the plaintiff's, to the defendant's entire profit from the sale of the product, as applied to a world in which the design was the product as a whole, and in which you are an intentional infringer. That might have made some sense. As we start to apply the design patent regime to smaller and smaller pieces that go into a much larger world, it seems to me to make no sense whatsoever.
Don't copy the design.
Don't have to copy the design, Perry. You can be an independent developer.
It doesn't happen that way.
Well, so if we wanted to change design patents to require copying, I think I'd be a lot more comfortable with some of the doctrines we've got here.
But I think what you're forecasting something. There's an intuition behind. I will acknowledge that there's an intuition behind your point, which is that some smart troll is going to start picking up component design, and maybe this will become a big issue. But I don't see it as a big. I don't see that happening now under current law.
Can I just
what I do see happening? What I do see happening under current law is a degradation of intellectual property remedies, and we see this vaunted intellectual property system that we've got that was the envy of the world in terms of spawning a level of innovation and creativity to the extent we can prove that there's causation behind this correlation, and now the pendulum swinging, I would suggest, too far in the other direction. So I worry about attacks on remedies right now, because I think even skeptics of aspects of the intellectual property system would have to acknowledge right now that the world of remedies is in kind of deep turmoil with consequences for the economy right around us, with consequences for the American economy writ large in the world that that are very worrisome.
If I can take issue with a little bit of that, one thing is and not to go too much into the whole smartphone litigation, but this is not the first time it's happened. I mean, the Wright brothers were notorious for asserting patents back in the day when they had a number of them. Empirically, it showed it stifled innovation. It ultimately took the U.S. government stepping in as a result of World War I and basically saying that there could be competition in this area. So and there are many other historical examples we can point to. So I don't think that there's evidence to substantiate the idea that design patents in particular were somehow responsible for causing innovation in Silicon Valley. I just don't see that connection at all. I do somewhat disagree with that, not necessarily that I think it's as a policy matter as to what kind of remedies should be here, but I also actually do disagree that the current law requires this, and that's something that will certainly play out in our litigation. There's precedent in our view, these piano cases really. Going now, like so many design patent cases, the precedent is a long time ago. These are Second Circuit decisions from like 1915 and 1916. But there, in fact, the Second Circuit reversed, where the profits on the entirety of a piano were awarded under the same statute. And in fact, the Second Circuit said, well, no, the design patent is only for the outer works, the casing rather, and you can't just simply be awarding the profits that are attributable to other, like the inner workings, they called it, of the piano. Call it apportionment, call it causation, call it what you will. The fact is that we do think that there are some limitations already that are in place and should be applied. But certainly at a policy level, that's obviously a question too of, why should design patents have that kind of remedy behind them today?
Can I just make a brief response? Michael's suggestion was sort of the causality of the U.S. IP system. And look, if the remedies are what drives it, the remedy of the entire profits has been around since 1887, right? And yet that suddenly we got all this innovation around smartphones in 2007 or so, and that was directly causal. Like, shouldn't we have had smartphones back in the 1800s, right? So, what happened? What happened right around 2000 is the PTO moved to nicer offices in Alexandria, and so I am going to submit that was the causal result, right? So you can actually look for a few natural experiments where we did suddenly give more protection, and the one that I think has been most empirically studied was the European Union created database protection. The U.S. decided not to in the Digital Millennium Copyright Act. We sort of threw it out, largely I think because of Feist. The Europeans gave it, right? And went, because it was being driven largely by the European database industry, and in the years after the directive was passed in Europe, the European database industry tanked relative to the United States, which did not have protection. So this notion that the more protection we have, the better we're going to do is, at least in the most prominent example I know of, been disproven. And if we're going to point to causality, you sort of need to have a natural experiment. And a damage remedy from the late 1800s, I don't think, is a good natural experiment.
Let me ask John Pratt to talk about pretty much anything he wants to talk about, because we haven't heard from you
yet. I think that at this point, this is an interesting patent. The one I was trying to pull up. The only things in solid lines are part of the corner and the outside of the wheels and a little bit of that handle up there. So that's an example of the extreme use of broken lines.
So if I had that on my car, I'd infringe. Right, a little bit of handle in the...
Yeah, apparently. I don't think that patent has been tested, but it's 5 o'clock. I didn't realize before the program that there would be voting here, but I wanted to. I got this patent for a client a little more than 14 years ago, so it's safe now to talk about its validity. But as you see, it is not what you might have thought, a beer keg, but rather a beverage cooler that looks exactly like a beer keg. And there was a beer keg that looked like that at the time. My question is, valid or not? Valid?
Subject to what he claims, which is a beverage cooler, not a beer can.
Where's that in the claim?
Yeah, what's
What was in the description?
It's the title.
Let's see the prior art.
It's not the claim.
Take my word for it. It looks exactly like those drawings.
The prior. What's the claim say? Beverage cooler?
A beer keg.
Which was a metal pressurizable beer keg.
Did you submit that to the PTO and your
It was cited, yeah.
information disclosure?
Yeah, and the argument that overcame it was, look, here's a cross section, and you can see there's insulation in the wall of this thing, and this is not a beer keg, but it's a cooler.
But that's what the insulation wasn't functional.
And the, and the top came off. But that's my contribution as we approach.
John, you're understating your contribution. Since you got that patent, the beer industry in this country has flourished.
That's right.
That's clearly caused.
That's ridiculous.
Well, the answer, of course, is the lawyer's answer, it depends. And Perry would say it depends on what the prior art is.
But if I'm understanding it right, as long as I do it with a dotted line, it doesn't matter.
So yeah, so like
Right.
Yeah, I can make it look like a cell phone.
I think the
And
question
if the icon's on a computer, it's still infringing.
The question is, how much of it do you do in dotted lines and how much?
yeah,
Do you-
I can't remember the exact case. There was a prism, or kind of a prism. There was like a stick of butter in one case. There was like a meat product in another, and it was cited as this stick of butter in mine, this meat product would never make this happen. I said, no, that's not area, food products, whatever. So I'm just wondering, based on the panel care practitioner again, academics, what
Good.
I just, first of all, with respect to this, we have that pretty clear that the title is of no moment. We're really talking about forms here, what we're protecting. So with that form, we turned it on the other side. I'm assuming that this cake was exactly shown in prior art, okay? Like that, then you could have anticipation in that situation, okay? Irrespective if it's for a toy cake or for an actual cake, once this is housing. Remember, this is a very narrow right. I don't know if people get sort of spooked about something like this. It's a very narrow right. It's shown as cross sections of the interior that have to be like that. Probably what got into the home with respect to the deal. As far as what you show in dotted lines, remember too that these are going to be played out from the video. So if you do have something like this, sometimes it's helpful to take, maybe you could show an individual with a beer can actually drinking it in dotted lines, okay? And it helps with classification at the USPTO too. I mean, these are tricky cases. Sometimes you get a computer case that's in the form of a golf ball. okay? So how are you going to sort of get away from the golf ball prior art strategically? I mean, if that exact dimple pattern is found on an actual golf ball, I think you're out of luck. Or maybe you can show that it can be separated into two parts, okay? That might be well. Maybe you can, and that would be something that's solid. But in dotted lines, perhaps you could show an individual using the workstation itself to help you when it comes to perhaps infringement. But key to note that at least here in the States, the current laws, the nature of the product is not going to affect the scope.
Classification and search.
That's one area.
So thank you for jumping in to help conceal the fact that we didn't actually have anybody on the panel who knew the answer to the question. The reason for that, and the very last question I'm going to ask today is we got a bunch of people who are here on the panel, who most of whom are not actually design patent people. We are general IP people who happen, for various reasons, to have encountered the design patent system. Let me ask the final question to Michael Jacobs. You just spent a lot of time in design patent land, and for you at least, I think that was a new experience. What's the most interesting thing to you as a non-design patent lawyer about wandering into the world of design patents?
Well, plainly, we've wandered into kind of a social group that knows each other very well. I mean, we've had the benefit of several of the members of that group today, and all of a sudden we're kind of invading the design patent world. I think the way general litigators invaded the utility patent world maybe 15 or 20 years ago, query whether that was good for utility patents or not, query whether this will be good for design patents or not. I think one thing that one confronts is, as with utility patents, you confront design patents and there are all these artifacts and barnacles, in raison. I mean, what a nutty, can you believe that? I mean, a design patent on a drill bit? And that becomes something that, it's just, so you see the nuttiness of the design patent world as one often also sees the sometimes the nuttiness in the utility patent world. And then there's the issues that we see that say Michael's team and our team saw that have never really been litigated before. And I think it was because both teams were kind of fresh to the world and developed issues and that'll be teed up maybe over the next year or two, and we'll get some clarity on them. The last point is that there's this statute. This always strikes me about the patent world is we've got say in design patents, we've got the Gorham test. The test for infringement is right in the statute. Apply the design or a colorable imitation, and you're liable for infringer's profits. And yet, because this world has, I think because the design patent world has kind of lived on its own over the last 120 years or so, people are citing Gorham and starting with Gorham instead of with the statute. So those are the kinds of things that, as an outsider to this world, one confronts and finds interesting.
Well, design patent world, welcome to the tech world. Tech world, welcome to design patents. And thank you all for coming.